Hi, Jim. Well, thank you for doing this yet again.
You're welcome.
Appreciate it. I think probably the best thing to do is if you want to just kind of begin by introducing yourself. I mean, I gave them a little flavor for some of the things you've done in your career, but just maybe a little bit more about your background so that they know who's talking to them this morning.
I'm originally from Wisconsin and grew up there, went to high school and college, attended Marquette University. I was actually there when they won the NCAA basketball championship, so that dates me a little bit.
None of these people were born, Jim.
Yeah,
I don't care.
I know. I taught in a high school in Houston, Texas after college, and did that for about 4 years, and then decided to go to law school, and went back to Chicago to go to law school, and following law school went to work for the U.S. Attorney in Chicago. The way that happened was I did an internship in that office while I was in law school, and it happened to be a time when the Department of Justice was growing quite a bit. They were hiring and increasing the size of U.S. Attorney's offices, so I was kind of in the right place at the right time, and they decided, well, we'll hire a couple of the interns, and I ended up being able to go from law school into that position. After a while, I eventually got to do some supervisory work, which was a great honor, and it was really very fulfilling. Your job basically was to work with other prosecutors and brainstorm problems that they have in cases, get them ready to try cases. And I also maintained a docket of my own cases and investigations as well. And I was also very lucky in that I didn't get pigeonholed in a particular type of prosecution. Not that that's always bad, but instead of specializing in something, I had the good luck of working on a variety of different types of cases. Obviously, a lot of run-of-the-mill cases you do, like some guy stealing mail or something like that. But you also do, I also worked on cases involving drug cases. Obviously, that's a big part of the docket. I did some work with fraud in the financial markets. I did a number of undercover type investigations, some corruption cases involving police and judges. And then, of course, with the supervisory work, I had a small hand in cases all around the office of different types. So I was fortunate to get that kind of exposure. It was, I think, almost the perfect preparation to come and teach. Although it's funny, the people I went to law school, I think, probably chuckle and laugh at the fact that I ended up as a teacher, because when I was in law school, I didn't really aspire to be any of my professors. I wanted to do something else, so it was a bit ironic that I ended up coming back to teach. But I've enjoyed it tremendously, maybe for the same reasons I enjoyed teaching at the high school level years ago. It's worked out well. So that's a little bit about my background.
Well, of course, the most famous or notorious case you worked on was the CIA leak case and the outing of Valerie Plame. Could you talk just a little bit about what your role was in that? Because that was, at the time, now 10 years ago, very, very high profile.
Right, and I don't know for how many of you this was on your radar screen, but it was an incident that happened during the Bush administration where there was a disclosure made to some reporters, a number of reporters, that there was a CIA agent, and her identity as a covert CIA agent was outed, as Pat said, and got into the papers. And the question was, who did it? And as often happens when there is an investigation of high-ranking White House officials, they decided, instead of having the regular chain of command in the Justice Department do it, and they were appointed by the president, obviously, that because of that conflict of interest, they ended up appointing a special prosecutor to deal with the issue. And it so happened that the fellow I was working with on my leave of absence, who was the U.S. Attorney in Chicago, got appointed to deal with this case. And he looked around him to the people who were working with him in Chicago to staff the case, although we worked with some people out of Washington as well. And we undertook to do this investigation. And it doesn't take a genius to realize where it went. If you have news reports from based on confidential sources that reveal classified information, eventually you're going to investigate, exhaust all of your leads, and it's going to end up focusing on the reporters. And what we did is, because of the extraordinary nature of the case, the President of the United States had said he thought this was an extremely serious matter and he wanted us to get to the bottom of it. And so we ended up pursuing testimony by the reporters. And of course, the reporters view their relationship with the sources as confidential. And so it broke out in litigation. And that was one of the things that I had a role in, was the litigation with the news media over the confidential sources. This eventually played out over many months, as the litigation process tends to do, and eventually the courts agreed that the reporters had to give up their sources. Several of the reporters did so. One of the reporters, Judith Miller of the New York Times, resisted, and she actually was held in contempt. And the cliche about civil contempt is that the person who's held in contempt has got the keys to the jailhouse in their pocket, because all they have to do is agree with a lawful order and they can get out. And after 85 days of sitting in jail, she took the keys out of her pocket and got out, so to speak, and agreed to comply with the order. We ended up getting the testimony, and in October 2005, we ended up with an indictment of one person who was the chief of staff to Vice President Cheney, and he was indicted on obstruction of justice, false statement, perjury charges, and that case was pursued eventually to a guilty verdict at trial, and eventually he was sentenced to 30 months in prison, and President Bush commuted the sentence, but then famously at the end of President Bush's term didn't pardon Louis Libby, who was the defendant, and actually if you read Vice President Cheney's memoir or Bush's memoir, that was a major incident right at the very end of the Bush administration, where Vice President Cheney was campaigning for a pardon, and President Bush resisted and refused to do it. So it was basically the last big decision of the Bush administration was about the Libby pardon. So that was kind of the aftermath of the litigation that I was involved with, and it was an interesting thing to be working on a case that had a lot of media attention, although I can tell you, what you learn very quickly is that a lot of it is kind of noise, that if you know really what's going on in a case, what you hear on the cable networks really isn't always very accurate.
Yeah. Well, you've worked on a number of high-profile things, complicated things. You've had these positions of great responsibility. But you and I went to the same law school, and we didn't know each other. We were the same age, but we missed each other at the law school. I was wondering if you could talk a little bit about how law school prepared you for this, or didn't, and what you did to prepare yourself for the career that you eventually had.
Mm-hmm. Well, law school can only do so much. I mean, it's an important thing to go to class and to learn the language of the law and to learn the basic areas of specialty, contracts and torts and property and those things, and it's important to do that. I think that there are other things, though, that really help. I can tell you one thing, at the risk of embarrassing my friend. A course like this would have been really nice to have, and we didn't have anything like that at our school. the idea of getting a perspective about the profession and starting that process early in the 3 years, I think is really a great idea. And in fact, it's an idea that's kind of gaining a foothold now as a lot of other schools are getting interested in what Pat and people here at the law school have created. I think it's really important to start thinking about that. And I think also, look at what's going on around you at the law school. One of the things I tried to do when I was in law school was take advantage of all the little extra things, like guest speakers and that sort of thing that's going on at the law school. When you have an opportunity to do that, I would strongly recommend you do it. And I know I've been there, you know, where you see the sign, right, and it says there's going to be a guest speaker, and when you first see it, you say, that sounds like a really great idea. And then when the moment of truth comes, suddenly going home and watching television sounds a lot better. And so I know how that feels, but I would urge you to try to make the extra effort to go to those things, because some of those things can be game changers. And I have an example of that that I've shared with Pat in the past, and that's that when I went to law school, I had no idea what I wanted to do with it. The thought of law school just sounded good, and I'll figure out what I want to do later. A lot of you may be in that boat. And I didn't go in thinking I wanted to work in prosecution or criminal defense or work in a big firm on financial stuff. I had no idea what I wanted to do. And one day there was a sign up that said that one of my professors was going to be giving a talk, and it was a brown bag lunchtime thing. And he was a fellow who was an expert in labor law. And I took his labor law course, and very difficult, tough stuff. It kept me away from labor law.
Me too.
Yeah, but it said that he was going to be talking about an experience he had during World War II when he was a very young lawyer. And after the war was over, he was assigned, he was a lawyer, he was in the service, he was assigned to the Nuremberg war crimes trials as a young lawyer. And he never really talked about it very much. I think he made it a point not to talk about it. And he was going to give this brown bag talk about being a prosecutor at Nuremberg. And so I went and watched, and of course I was getting there late and ended up sitting on the steps of this classroom, looked a lot like this one, and listened, and it was spellbinding. That's the only word I can think to describe it, where he was talking about, you know, assembling the evidence against this group of Nazi war criminals. And, you know, and we're talking about the prosecution essentially as part of its case proving the Holocaust against these guys. And it was pretty stunning. And I remember thinking to myself, well, okay, that's obviously the case of a century, right? I mean, and so if you go into prosecution work, you're not going to prosecute the Holocaust. But, you know, maybe if I prosecute someone for stealing United States mail, you know, it'll be a little bit of that, a little sliver of that kind of public service work. And I walked out of that classroom that day thinking, you know, that's really pretty neat, what he was doing. And maybe there's some little slice of that that I could get involved with. And that led directly to my going to work in the U.S. Attorney's Office as an intern, just to do it. I didn't get credit or anything for it. And that led to eventually getting that position. And I think there's just a direct causal connection between my taking the time to listen to that talk that day and what I ended up doing. And so I'd encourage you, don't miss that talk that might make the difference.
When you had finished the internship, you got hired, and you're a brand new lawyer at the U.S. Attorney's Office. Tell the students a little bit about that phase, and maybe some things that surprised you, that our law school didn't really prepare you for, things that you found particularly challenging. I mean, they're gonna be brand new lawyers very soon. So talk about being a brand new lawyer in the Chicago office.
What surprised me, I had just graduated from law school, and my first day as a lawyer was in the U.S. Attorney's office. Everything surprised me, everything. And, you know, like having a secretary, that surprised me, you know, and how to deal with that. Everything did. But I'll tell you one thing about practicing law that you should start thinking about now is a lot of it is kind of people skills, of communication skills, of dealing with all different kinds of people, like a secretary, or a law enforcement agent who brings you a case, or a colleague, or a supervisor, or a judge, or the clerk of the judge. And you interact with lots of people, witnesses, defendants. You interact with lots of people. And it makes the job very, very interesting, but it's really a skill to learn how to communicate and interact with these different people. And so it's something that I would start thinking about. I know at the beginning of the second year, you do a week where they talk about counseling skills, and you do some simulations, and that's a great spark to start thinking about those sort of things. But a lot of practicing law is people skills and interacting with people. It's really much more in some ways than the dusty law books or the computer screen where you're looking up cases. Another thing I think that surprised me in the kind of work I was doing, and I think this is true in other types of work too, is you do a lot of investigative work that in a U.S. Attorney's office you're very often involved in the actual investigation. It's not like they just hand you a file and you go to court. You're involved in building the case. And they don't teach a lot about that in law school, about doing investigations. If you're talking about an undercover investigation and the scenario that's going to be used, a lot of that is just common sense. But when you're dealing with it kind of for the first time, it can kind of come as a shock where you know, the law enforcement agents come in and they tell you how they're going to do an undercover scenario and what they're going to say to the alleged bad guys, and then they kind of turn to you and they say, okay, is that all right? Do you approve? Do you sign off on it? And it's like, whoa, wait a minute, let's try this again and go back through it. But that's something that, as I say, you don't learn a lot in law school about, but it's something that you're involved with. And it's something actually that makes practicing law in any kind of litigation situation very interesting. Because if you're at all curious about the world, it's a wonderful thing, because you learn so much in investigations. Now, some of it's a little intimidating. I mean, obviously, one reason I went to law school was that the sciences and math were not my strong suit, and then you find yourself dealing with some expert witness who's all about science and math, and you not only have to kind of understand what they're telling you, but you've got to be able to convert it for a lay jury in a courtroom, and it can be challenging, but you learn a lot of stuff, and you get involved in the facts of cases, and whether it's a drug case where you're learning about the way drug dealers do their business, or a financial case where you're learning the ins and outs of some financial market that you'd never known anything about. It's really very, very interesting. One last thing I'll say was a surprise is you may not know that probably over 95% of all cases in the federal system and in most state systems are resolved not by a trial, but by guilty plea. And one of the things you do spend a lot of your time on if you're a prosecutor or a defense lawyer is guilty pleas, negotiating the terms of guilty pleas, having the defendant enter the plea, and then going to sentencing. And so a lot of what you do is kind of like contract law. You're writing up a contract where they agree to plead guilty in exchange for certain concessions, and most of your cases are resolved that way. So you end up actually doing a lot of contract law. So if you're taking contracts and you don't really like it, it may mean prosecution work is not for you, because you do a lot of offer, acceptance, consideration. That's kind of the language that has been adopted, and that law has been put into that aspect of prosecution work, and so you do a lot of that.
A lot of what you described in terms of investigation, and then on the civil side, on the side I was, it'd be settlement rather than police. Those really are in common among different kinds of practice, but prosecution is different in some ways, and the students have been learning about that this week. Could you talk a little bit about that special role of the prosecutor and how you viewed it and how that folded into how you enjoyed your prosecutorial career?
Yeah, I mean, I enjoyed the idea of it, in part because it's public service. And, public service, I guess, is roughly defined as making less money than you could earn to do something that's supposed to be of value to society. And it's a job that needs to be done, but I viewed it as a real privilege to do it. And it's a difficult position in a way because you have to deal with your competitive instincts sometimes coming into conflict with what is the right thing to do. That, we have this adversarial system, so you think about a prosecutor and then defense lawyers on the other side, and the idea is these adversaries fight against each other, and that hopefully the result is justice and the truth come out of that. But the prosecutor's role is not just to be an advocate, because if you think about it, who's your client? Your client basically is a sovereign entity. If you're a federal prosecutor, you represent the United States. And the United States is not just a person, right, or the Congress. I mean, the United States is the entire polity that includes all the people who are part of that polity, including the defendant, usually, right? So you have an obligation to represent the United States and not just win the case, as you read in Robert Jackson's statement and the Berger case that you guys were assigned, but your job is to see that justice is done. And notice how that comes into conflict with being an advocate, in the sense that as an advocate you think, okay, I've won 40 in a row, right? I'm a winner, okay? But that's really not the way you have to judge it. The way you have to judge it is, did the case come out the right way? Was the right thing done? And very often you're in the position of saying, here's some evidence. This evidence isn't going to help me win. It's going to help them win. But I need to give it to them because that's my obligation as a minister of justice, so to speak, as they sometimes say. And you have to put those competitive instincts on hold. And that can be a trick. And I know that you guys have done some reading about prosecutors that went off the tracks, and the failure to check those instincts sometimes leads to that happening.
Yeah, and I think this competitive drive you talk about certainly is something a lot of law students can identify with, and certainly anybody who does litigation can identify with. But if my reading is right, there's a lot of prosecutors that do go off the tracks, particularly with this Brady obligation. I mean, other than just the competitive zeal that we all have, what kinds of things have you seen tempt prosecutors to go off the tracks or actually lead them there?
Well, there are several things that can cause it. I mean, one is the competitive instincts where you just want to win. Part of it, I think, is you believe in your cause, in your case, to the point where you don't think that the other side is possibly correct, or you demonize the other side. You start getting these kind of attitudes of, I'm the prosecutor, we represent justice and right, and the defendant is scum, and they're bad people, and the defense lawyers are terrible for representing them, and you start getting these kind of almost religious attitudes about your role, and I think that can cause you to make mistakes, obviously, and say, well, if it's going to keep us from winning the case, it's obviously something we don't want to do, and you end up just being kind of self-righteous about your role. Sometimes it can be a culture in a prosecutor's office where from the top down there's this sort of message that we have to win, we have to win, we have to win, because maybe the boss is an elected official, and you end up kind of cutting corners. And you know, how does anybody fall into bad habits or breaking the law? You know, you end up kind of believing in what you're doing is right, and ends justify the means, and there you go, sliding down the hill.
I don't sense that you were ever in such an office. You were never subjected to that kind of a pressure. I didn't tell you I was going to ask you this, but if you were in such an environment, or if one of the students found themselves in an office culture that was tainted in that way, what should they do?
Yeah, that's a very good question, and it's actually a question that a number of my students have asked me over time, and very often not in the hypothetical where they were kind of confronted with it after graduation. I have been very fortunate in that the offices that I've worked in, I think, very much occupied the high ground, that there was an attitude and a culture that we were going to do the right thing, and we were going to do everything the right way, and we were going to support each other in doing it. And if it meant that in a given case we ended up not pursuing a case, or if we had to give over evidence that the defendant used to his advantage, that was the way it goes, and that was our job. That's what we were supposed to be doing. And I think that kind of culture is one that hopefully a lot of offices have. If you're in a situation where the culture isn't right, it's an ethical issue. And you know, you learn a lot about ethics in law school. Prosecutors' jobs are jobs where almost every day you're dealing with ethical issues and challenges, and hopefully doing the right thing. And I've had students who said, you know, my boss really says I'm not supposed to turn over this information. I really believe that I'm obligated to do it. What do I do? And of course, they know the answer to the question before they ask me, but the answer obviously is you've got to pursue it, and maybe it's a question of saying, well, you need to take me off this case then, or maybe it's a question of deciding you need to work somewhere else. And those kind of things do come up. And in prosecution work where you have such a high ethical standard to meet, and so many obligations that other lawyers often don't have, that you sometimes are confronted with those difficult situations. Now the good news is that doesn't happen all the time, and it doesn't happen, I think, frequently. And most of the students I know who are out doing prosecution work have had a very positive experience, and of course reap the rewards of doing that kind of public service.
Well, and I'm glad you said that, because I want the students to have the good news, but I think it's also part of our job to sensitize them to the reality that at some point somebody's going to say, well, out here in the real world, right, and then ask them to do something they shouldn't do. Let me switch to something just a little bit different. I mean, I ask you what was surprising about being a new lawyer, but you have to make this transition from novice to expert, from, you know, you're the new lawyer on the block to eventually becoming a supervisor and so on. I was wondering if you could talk a little bit about that transition, about what young lawyers should do and what you did to learn the lessons they need. And I want you to start by explaining to the students how you learned to keep an extra suit in the office.
Okay, yeah.
Little thing.
Yeah, Pat likes this story. Keeping an extra set of clothes around your office. You think, well, why would you do that, right? Well, for me, I learned it this way. I was, at the very first day of my very first jury trial, was going for jury selection, and I put on my best suit and my best shoes, and I was nervous to be going to court. I was trying the case with a more experienced person. I wasn't on my own. And I was walking to the Federal Building in the Loop in downtown Chicago, and I was walking by a restaurant called the Berghoff. It's a German restaurant. And they were offloading kegs of beer. You can see where this is going, and hopefully. what they would do is they drop these metal barrels off the truck onto an empty tire, and that would be the cushion. And one of them took a bad bounce and it hit the curbing and split the seam on this metal barrel, with the result being this jet of beer shooting out right as I was walking in front of the Berghoff restaurant. And I'm not a very good dancer, with a stream of beer coming at my legs, I was able to kind of dance around it, and the barrel was kind of going like this, so the spray is all over the place. And eventually it got me in the legs and the shoes. And so I walk into the federal building reeking of beer at 7:30 in the morning, and got on the elevator. One of my supervisors gets on the elevator, I'm on there ready. He jumps on at the last minute as the doors are closing, much to my horror. And, halfway up to the 15th floor, he's like, "What is that I smell? Is that beer? What is that?" So it was very embarrassing. I ended up going to court, and I tried to clean myself up as best I could, but I really reeked of beer. And the whole day was very self-conscious about anybody. And so we're having sidebars during the jury selection, and the judge, a very nice woman, knew it was my first trial and really wanted to be inclusive and let me participate. So she's constantly saying, "Jim, come on, get in here." And I'm afraid she's going to smell the beer if I get close. So it was a very long day, and one that I was teased about for a long time thereafter.
Yeah. Well, okay, that's one little lesson. But having learned that, I started that. How else do you recommend the students? What should they be doing in these first few years in practice to move up?
Well, one thing I would recommend is, and most people would tend to do this naturally, is look around you to people with more experience, or maybe the same level of experience, but someone you really respect, and try to watch them and learn from them. And I mean, the fancy word for this is that they would be a mentor for you. But I think that's really important, to look around at other people and to kind of informally learn from them. I had a couple of guys I worked with who were really, really good, and I think they looked at me as a colleague. I looked at them as my mentors. And they would probably say, "Well, I learned more, from you than you learned from me." That, they would probably say that to be gracious. But I really did learn a lot from some of these people. I'll tell you one thing I learned. I think of prosecutors as being of kind of two types. You have some of them who are very deliberative, and they're thoughtful, and they think through things, and they're very patient, and they're very cautious. And I put myself in that general tendency, right? And then there are other prosecutors who are very active and aggressive and thorough and energetic, and they get things done. And my mentor was a person in that camp. And of course, neither one of those at the extreme is going to be a really good prosecutor. That the question is to combine those two traits. And what I learned from my mentor, several mentors, is I looked at people who were of that really aggressive, get things done, thorough kind of attitude. And I said, I need to be able to do that. That when we decide to pull the trigger and do a case, to really pull out all the stops and do that. And so I would watch those people who had that trait and watch how they went about their work. And then when it was time to really get things done, that's the way I would act. And I imagine some of them looked at me and said, I need to be a little more deliberate, thoughtful, and cautious, and I need to kind of do that first before I pull the trigger and start doing all this stuff. And some of it's teamwork. That a prosecution office is not just individual people working on their own. It's a group of people around a conference table deciding what to do, and you need people, I think, with both of those tendencies to create the proper balance so that you get the right outcome. But so my advice for beginning is to spot people who have traits that you admire and watch them carefully, and that's a very important part of the learning process.
I know from time to time you told me that one of the things that you did and found important was, I mean, outside the office, reading about great lawyers and reading about great trials and taking the initiative, in effect, to continue your education.
Right.
Right. Could you talk a little bit
Sure.
about that?
Early on, one of the things that was really intimidating to me at the very beginning was that everyone would tell me about how experience was so important. You know, that, you know, they'd say, oh, you deal with this defense lawyer and he had lots of experience, and you'd think to yourself, well, if experience is so important, how can you ever catch up, right? I mean, you know, you know, I have to wait 25 years before I can really say, okay, I'm a good trial lawyer. And I don't want to wait 25 years before I can say that. So how do you bridge that gap? And the answer is the mentoring process I mentioned. It's listening to stories around the water cooler about what happened in court that day, and taking advantage of the experiences of other people. And then I think it's reading. And I joined a book club, and I was way too poor to belong to this book club because they were very expensive books. But every month I would get a new book, and it was a book about a trial. And some of these books were really extraordinary. The first one that they sent me was about the Lindbergh kidnapping case. And it was basically the trial transcript and a lot of really detailed reporting. It was written by a guy who actually watched the trial as a reporter. It was very detailed. And I'm reading it, and I'm learning all kinds of stuff about trying a case, both good things and bad things. You know, with the lawyers sometimes did bad things, and I learned from those as well. And I got this idea that, in a way, that was kind of like bottled experience. And that if I made the effort to read things like that, take advantage of the stories people were telling, to learn from them, that I could advance the ball. The other way is kind of your own personal continuing legal education course. I mean, so much of what you do as a lawyer is the spoken word and the written word. And it seems to me you can learn a lot about those things by doing a lot of reading. And read something you like. I mean, I personally, like my friend Pat here, I like biography and history. And if you take a really great historian or biographer, they're a really good writer, you read that stuff, you enjoy it, but you're learning. I mean, when you read and you interact with the language, you learn from that. And to kind of make it a habit. And it's not like it's some kind of genius thing. It's kind of basically saying, you know, it's better to light one candle than curse the darkness, right? I mean, that you don't have to read the whole library to learn. You kind of take individual pieces of it that you like and make it part of your life's habit to read those things, and that helps. And, you know, you might want to read some psychology, you know, if you're interacting with witnesses. And you're thinking, how do I interview these people? Doing a little bit of reading on your own can help. So it's not just going to courses, you know, continuing legal education courses, but trying to ingrain habits that will help you learn as you go in little bits.
I want to ask you about one particular part of your role as a prosecutor that I think a lot of people find difficult, or the prospect of it difficult. You spend a fair amount of time interacting with opposing counsel. And I've talked to the students a little bit about what that's like. You know, you've got somebody just as devoted as you, whose job it is to beat you, and yet you need to deal with them in order for everybody to get their job done. Can you talk a little bit about that process and how you handled that need to cooperate in a situation of inherent conflict?
Mm-hmm. Well, here's one where I was looking around at my mentors and examples, and I was seeing different types of behavior that people adopted. And you have to kind of find a style of interacting with opposing counsel that you find comfortable. Some people take a very business-like approach, no nonsense, kind of tough approach, and then other people are a little more open. I was probably in that category, where I think the reputation I developed dealing with counsel is that I would be open with them, as open as I could, and not endanger somebody or give away something I shouldn't give away, but that I would be open and would share information to the extent that I could. And you develop a reputation for honesty too, and it's very important. If you get a reputation for not being straight and not being honest, believe me, it gets around. The defense lawyers talk to each other just like the prosecutors do, and if you get a reputation for not being honest, you can never undo it. And so it's very important to develop your reputation and your style. And what I would do is watch how other people do it and choose a style that suits you, and you'll learn it from other folks.
In just a minute, I'm going to turn this over to the students and let them ask anything they want to ask. But as you know, I always give our guests an opportunity to say anything you want to say, any advice you have for the students, maybe something you wish somebody had told you as a first-year law student. What do they need to hear that 30 years on you can tell them?
Well, if you're thinking about criminal law, there's a possibility that you're thinking from one point of view. And you're thinking, defense work, that's very appealing to me, or prosecution work, that's very appealing to me. And what I would encourage you to do is not to think of it as like one tribe or the other tribe. And I know there's a lot of reason that we think like that, like there are these two opposing camps. And of course, if you go to a prosecutor's training, I was at one last week, that the prosecutors view themselves as the good guys, and they talk about the defense lawyers like they're the bad guys. And if you go to a defense training session, they're going to view themselves as the champions of justice and the prosecutors as those dirty persecutors who railroad people. And I understand why they do that when they meet. I mean, that's the way we motivate high school football teams, right? They're the bad guys over there in the next county, and we're going to beat them, And that's the way it is. But what I would encourage you to do is not to think about those two tribes, but to think about the criminal justice system as having two important components, both prosecution and defense. And part of that, I think, is to respect the other side and their role in the system. And part of it is just good competitive strategy. That if you can actually learn to think, if you're a prosecutor, if you learn to think like a defense lawyer, it's gonna help you competitively. Because I've often said that my mentor, the fellow I was talking about before, he was a prosecutor almost his whole career. And he's the best defense mind I've ever met. When I had a case, I would go to him when I was prosecuting it, and I'd say, okay, Dean, what do I need to do? And he would scare me to death with the insights that he would come up with after reading my case, and I would prepare to deal with those issues. And most of the time, the real defense lawyers, wouldn't see any of those things. And I would be prepared to meet them, but they wouldn't even come up. But that's an example of somebody who was able to think even better than the opposing side. And I think that's an important thing to do if you're going to get into criminal justice. You have to accept the noise about prosecution versus defense. That's inevitable. That comes with the territory. But my recommendation to you would be to try to think like a criminal lawyer and not as one or the other, because I think it can lead to tunnel vision on both sides.
Well, and that's part of the genius of the LLM program here, in federal criminal practice, which you designed, you created, and you direct, the prosecutors and defense lawyers are trained in the same room at the same time with each other.
Right, and my experience that I just shared with you was directly fed into the way we designed that program. And the idea is to train both defense-oriented and prosecution-oriented people together and have them interact. So like in Pat's class that he teaches with the LLM students, where they deal with ethical issues, you've got defense lawyers and prosecutors around the table talking about ethical issues and how they deal with them, and that to me seems like a very valuable approach. Much better than segregating them and having the defense lawyer say, okay, well, you know, what are the ethical problems that the prosecutor has, or vice versa.
What questions do you all have for Professor Fleissner? Yes, sir.
Given,
And again, I'm going to repeat your question for purposes of the recording, so forgive me when I do that.
given that either side of the criminal prosecution or defense has such a huge impact on people's lives, defendant, victim, how do you not take it home? How do you sleep at night? How do you leave it at the office?
Yeah.
Or is that a problem?
Yeah, again, the question is, you basically, given the enormity of the things you're dealing with, how do you personally deal with it and sleep at night?
Yeah, I've been asked the question before, you know, how do you sleep at night? Yeah. You raise a really interesting point, and that is, I thought it was part of the attraction of it, although it can be a burden occasionally. But you really do play an important role in people's lives. And I think, even if it's just a witness, you know, I mean, I can remember I think it might have been the first witness I ever put on the stand. Very nice lady from the insurance company, and all she was going to do was help me get into evidence some records. Right? So she's not a big player in this case, but she was petrified of going to court. You know, my first witness, you know, and she's just petrified of going to court, and asked me questions like, well, is the defendant, is he going to be there? And I said, well, yes, he's going to be there. That's kind of the way trials work, you know, he's sitting over there. And she was petrified. And part of dealing with her was to ease her concerns, kind of talk her through it, and make her feel okay with it. And if I had treated her brusquely and said, you know, listen, lady, you got to do this, you know, and was hard on her, it would have made it even worse for her. So it's kind of the small things that you can do interacting with people that will make it easier. You know, sometimes you deal with serious situations where people are really afraid for their lives and things like that, and those things are obviously a source of tension. But you know, if you really work hard, do the right thing, and you have a team of people working with you, you're able to sleep at night. You know, maybe occasionally a stiff drink helps, but you know, it's something you do get used to, and I found it isn't like you hear in medicine, you know, where people really can get burned out. I mean, I think that probably happens, but you know, I think sometimes doctors, just by the stress of what they're doing, get burned out, and lawyers can get burned out too. But
Why did you gesture at me?
yeah, as you learn in this course, right? Yeah, yeah. But I found in prosecution work that's not that common.
Other questions? Yes, sir.
You said that you were a high school teacher before you went to law school. Do you feel that your high school career, that whenever you taught, do you think that helped you out when you started at the U.S. Attorney's Office? The experience that you had with social skills?
Sure, I think it helped there. I think it helped when I came here to teach. You know, I think teaching is teaching. And I rarely say this in the presence of law students because for fear that they would find it to be insulting. But I mean, teaching high school students, I learned a lot about teaching and trying to make sure that things are simple and direct and not losing sight of that. And I think it helped me in the U.S. Attorney's Office too, because when you're trying a case, one of the things that's very difficult about it is that a jury are just lay people off the street. And you have to take a case, sometimes complex science, like I was saying before, and you have to make it accessible to them and simplify it. And one of the things I found, and now I'm going way beyond what I usually like to do with talking to law students, but one of the things about law school that I always found frustrating is that, and sometimes this is done on purpose, that a professor will kind of start at point 5, and they'll assume from reading the assignment that you got 1 through 4. And if you didn't quite get 1 through 4 from reading the assignment, you're way behind when the discussion starts. And I think that can be a good teaching technique to motivate people to really prepare. But one of the things I found is that some of the time it's better to kind of start at the basic, fill in 1 through 4, and then take off from 5 and have the more advanced discussion. And that's something you learn teaching high school.
Other questions? Yeah, yes.
Do you recall any particular instance in your career where you came close to going over the line because of the competitive nature?
All right, just for the purposes of the recording, did you have an occasion in your career where you felt yourself get close to that line, or I'll elaborate on it, or that you've just felt tempted?
Well, if you're talking about kind of Brady type stuff of having exculpatory evidence, I never really had a problem turning over stuff that helped the other side. I mean, I viewed that as kind of part of what I do. I worked in offices where the culture was such. I'll tell you one situation though that did trouble me, and it's a very complicated ethical issue. Is a case, for example, where you had someone who pled guilty and then they agreed to cooperate and testify. And I'm working with this person, and I'm going to present them as a witness in a trial where they're going to point the finger at their co-conspirators. And that's a very common type of witness. So you're dealing with a guy who is involved in criminal conduct, he's pleading guilty, he's going to testify. And the ethical issue here really concerns manipulation. That you want that person to perform well as a witness, and part of that is that they be kind of bucked up psychologically and prepared to do it. And I always thought it was a very interesting ethical issue of how far you would go to get that person to be the best possible witness you could do. And I'll give you the simplest example. Talk about people skills. You bring the guy into your office. You don't like him. He's not a good person. He's done lots of bad things. He's not very likable. You don't like his jokes. You don't like his attitudes. You don't like very much about him. But you pretend to be friendly to him because it's good for business. If you said to him, look, I don't want to talk with you, you're a jerk, let's just do our business, it's not going to get done as effectively as if you're nice to the guy despite the fact that you kind of loathe him personally. And that, I think, is a very interesting ethical issue of manipulating somebody to kind of get them psychologically in the position that you want them to be. And to this day, I'm not sure there's an easy answer to that.
Jim, I'd like to do this all morning, but you said you'd hang around for a few minutes if the students had anything else they wanted to ask you, so join me in thanking Professor Fleissner.